So without any further ado, I think LaRon is taking it first.
Good afternoon, everyone. As you know, my name is LaRon Baker, and thank you all for coming out today. So our ACLU today is about jury diversity, and what we can do to ensure that more people of color actually sit on Washington state juries, which is a major issue here and also across the country. There are many facets and many ways that people at the ACLU are working on this issue, trying to increase diversity. Nancy Tallner is doing a ton of work on this issue. And that work includes looking at source lists that often have really outdated address information for people, right? So if a source list for a jury pool has addresses that are 18 to 24 months out of date, there are a lot of people who are going to be missed when the summonses go out. Some of that work has to do with trying to increase juror pay. We all probably know that there's a lawsuit here in King County that's seeking to increase that. And some of the other work involves ensuring that there's clarity around when and whether or not people who've been convicted of a felony can sit on a jury. And as we know, people of color are disproportionately involved in the criminal justice system, so that lack of clarity around people with felonies being able to sit on jury really does have an impact. So those are some of the things that we're working on. But today we are going to focus on our work at trying to stem the use of peremptories, the biased use of peremptories to exclude people of color from juries. And specifically, we are going to talk about a proposed Washington State General Court rule that's meant to keep attorneys a little bit more honest in their use of peremptories and to keep them from engaging in racially biased motivation when they use their peremptories. So what is a peremptory? I'm sure most of you all in here know. But Black's Law Dictionary defines a peremptory challenge as one of a party's limited number of challenges that do not need to be supported by a reason unless the opposing party makes a prima facie showing that the challenge was used to discriminate on the basis of race. Whoops. And so peremptories are one of the oldest aspects of our legal system. There are many attorneys who believe deeply that peremptories are necessary in order to impanel juries that are going to provide their clients with the best decision making. And oftentimes they can be used to do that. But historically, peremptories have been used to exclude people of color from juries at great rates. And so this issue has come before the United States Supreme Court a number of times, and the most landmark case is Batson versus Kentucky. In that case, was an attempt to craft a test that would challenge what seemed to be a biased use of a peremptory by an attorney, right? So the Supreme Court, in acknowledging that the discretionary use of peremptories excludes a lot of people of color, decided that they needed to try to come up with something that would stop that from happening. And the reason for that is that when an attorney engages in a biased use of peremptories, there are three types of harms that occur that come from that. The court in Batson indicated that jurors must be indifferently chosen to secure that the defendant's right under the 14th Amendment to protection of life and liberty against race or color prejudice. So there's a harm to the defendant's right when a biased use of peremptory, or biased use of a peremptory happens. The court also said denying a person participation in jury service on account of his race is unlawful discrimination. So the juror who's excluded has an injury when we don't appropriately cabin use of peremptories. And then selection procedures that purposely exclude people of color from juries undermine public confidence in the fairness of our justice system. So if we have what we have now, which are disproportionately white juries, we have the exclusion of people of color, there is going to be a sizable part of the population that has deep concerns about the legitimacy, the ethicalness, and the efficacy of our judicial system. And so the SCOTUS came up with a test. to protect, right? So it's a three-part test. Party challenging has to articulate and say, I believe that this peremptory was used for biased reason. The party who sought to strike a potential juror by the use of the peremptory has to then articulate a race-neutral reason for the strike. And then the court has to make a decision about whether or not there was improper racial motivation. I'm sure that we can all guess that that step 2 is a really, really simple step to get over, right? So the Batson test has historically just not been an effective protection against the biased use of peremptories. And our Washington State Supreme Court, not that long ago, really weighed in on this issue. And on the fact that Batson fails to appropriately protect against the biased use of peremptories. The St. Cali case, there was a potential juror named Anna Tolson. She was African American. She was targeted for extra questioning after another juror mentioned race and the fact that there were not very many people of color in the jury pool. The prosecutor then turned to the blackface in the room and began asking her a lot of questions about her belief about the criminal justice system and fairness and whether or not she believed that the race of the jury would impact how they would perceive her credibility. There were other issues for sure, but it was pretty telling the type of questioning that she was subjected to that nobody else was. The appellate defense attorney is Lila Silverstein. She's fantastic. She's a cooperating attorney for us, and I just love to sing her praises. So she did a great job on this. And the court, in a fractured opinion, issued a lot of concerns about Batson and about how it's failing to protect Washington State residents from bias in the criminal justice system. What they said is, we also take this opportunity to examine whether our Batson procedures are robust enough to effectively combat race discrimination in the selection of juries. We conclude that they are not. 26 years after Batson, a growing body of evidence shows that racial discrimination remains rampant in jury selection. In part, this is because Batson recognizes only purposeful discrimination, whereas racism is often unintentional, institutional, or unconscious. We conclude that our Batson procedures must change and that we must strengthen Batson to recognize these more prevalent forms of discrimination. So our Supreme Court, in looking at the history of Batson in Washington State, indicated that in 42 cases, Batson challenges that have gone up on appeal, none of them resulted in a reversal. And looking at practices and engaging in some of the underlying social science, our Supreme Court said Batson is ineffective. And from reading the opinions, it's clear that they maybe tried to attempt to find a remedy, to figure out a new test, but obviously could not. But they proposed in there that we all are responsible for protecting the legitimacy and the efficacy of our legal system, and that we should begin thinking about what we can do. There, of course, are people who believe that peremptories should be abolished. Thurgood Marshall's dissent in Batson specifically says that there is no way that the Batson test will actually protect against biased use of peremptories, the racially based exclusion of jurors, because it's impossible to really tell whether or not an attorney is using improper racial motivation for exercising the strike. In part because oftentimes people are pretty clever and they can come up with a race-neutral way to explain the peremptories. Sometimes people are unaware of their own biases, right? And so they may actually be racially motivated by negative stigmas about people of particular population subsets, racial or ethnic groups, and not really know it. And sometimes there are kind of two reasons why someone might be excluded, a legitimate reason and an improper racial motivation. And so Batson, effectively, Marshall just said, this is not going to fix anything. It's better than the nothing that was in place ahead of time for their actual requirement that you show systemic exclusion of blacks and people of color. Justice Gonzalez, looking back over time, said it's clear that Batson isn't going to afford protections and that there's no test that can. So there are a group of people that are calling for the abolishment of peremptories. But there also are other folks who are really wanting to try to craft and create new ways that we can protect jurors of color from improper exclusion. So regular, loud, more perfect. Sal actually pointed this out to me. I hadn't run across it before, but this episode is about Batson. I would suggest you listen to it all. It's a 30-year retrospective, and in it is Jeff Robinson, who I'm sure most of you know. He is now our national Director for Justice. Thank you. And he's interviewed as part of this retrospective on Batson, and he articulates what it is we're trying to do with this proposed rule that Sal is going to talk to you about in a great way. And he actually has been part of the group that came up with presenting this. So it's a longish piece. It's about 4 minutes. But I think it's worth it.
Here's another argument I heard from Jeffrey Robinson from the ACLU.
And this is based on my experience of 34 years in the criminal justice system.
Jeff Robinson says if you can find some way to take race out of the equation, peremptories are super useful. And he told me about this one case.
Very high-profile homicide case in the state of Washington.
This case was incredibly complicated and also potentially involved a coerced confession by some undercover cops.
And there's a police officer on the jury panel. He says, I can be fair. I know the police officers that investigated this case. I've worked with them before. I think they're really good people, but don't worry, I can be fair. Everything about his background was saying, I do not want this man to serve on this jury. But he was saying, I can be fair. I could not exclude him on a challenge for cause.
Why not?
Because he said he could be fair. The fact that he's a police officer doesn't mean he can't be fair.
But isn't saying, I know some of these people involved in this case enough to get him dismissed for cause?
It's enough to get more questioning, but how well do you know him? Not very well.
So you're saying in that case, if you said, okay, Judge, I'd like to dismiss juror 17 for cause.
For cause, the judge would say, there's not a record for cause. I don't think any judge in this country would dismiss that juror for cause.
Wow.
And so a peremptory challenge is important.
So I've watched more jury selection videos on YouTube than any person ever should. And it's this amazing thing where you see these people, they're not necessarily used to being in a courtroom. They're certainly not used to being grilled in public by a bunch of people in suits. They get up there to the jury panel and they get asked these questions.
Does everyone agree that bias doesn't have any place in the trial?
Over and over again.
Can you be fair and impartial?
Yes, sir.
You're like a blank slate.
Yeah.
You're just going to listen to the evidence. Can you do all that?
Yes, I could.
Okay.
Nobody says no. Everyone feels like, yes, I can be fair.
And this is the time to tell us. That's why we're asking you this.
I'm thinking I could.
Okay.
I can be
So there's
totally
no-
unbiased. And I think some of them believe that they can actually do this nearly impossible task, and others, they know they can't, but they might say yes anyway.
Anyone who tries the case, believe me, knows that biased jurors come in. They don't reveal things. They lie about things.
There's people that when you're questioning them in a jury that you know they're lying to you. They're either trying to get on the jury or trying to get off the jury.
Biased people are being allowed to serve. So any tool that can help reduce the number of biased jurors on jurors is essential to justice.
So yeah, if you've got a really crappy outlook on jurors and humans, then maybe you need more peremptory challenges. But the way Jeffrey Robinson put it to me was that if you're using peremptory challenges the right way, it forces you to be like equal opportunity suspicious of like everyone. And that's the only way to be fair.
My parents were both active in the civil rights movement in Memphis, Tennessee, as active as two people you could ever want to meet, both black. I would never let my mother sit on a criminal defense jury. Because my mother's view about black defendants was, you're the reason I have to lock the door in my neighborhood. You're the reason that I get disrespected when I go out into the community, and I'm going to take it out on you. My father's position would be, I wouldn't believe a police officer if he told me it was raining and the water was coming down on my head. And so what this is about is actually putting into effect what the rules say. Talk to jurors and find out what they think.
But what about Thurgood Marshall's idea that, you know, if you have peremptory challenges, if you give people a way to discriminate, they will discriminate?
Well, I was born in 1956, and so in 1954, Thurgood Marshall argued Brown versus the Board of Education, which had a significant impact on my life. Thurgood Marshall was someone that I have respected and someone I have admired virtually my entire life. But I can't agree with him that I want all peremptory challenges eliminated.
And why do you think Thurgood Marshall, Justice Marshall, went straight to no peremptory?
I think Justice Marshall concluded that he did not have faith in America to be able to make these kind of decisions. And I understand why he concluded that.
And you do. You have that faith.
I still do. And how long that will last, I don't know. But I still do right now.
And for a discussion about what it is that we are hopeful about for humanity, what it is we're trying to do to keep bias out of the criminal justice system, Sal is going to talk about our new proposed general rule.
Great. You know, one thing about, I think everybody agrees, is that Batson doesn't work. I think, as Ron just told you, it's not just in our state, nationwide. It's statistics. It's amazing how it's used, okay? So I want to make sure that we start from that baseline because, and I presented on this to a number of groups and to a number of people, and what you can't do is try to say, okay, well, your solution isn't perfect. Yeah, no, duh. There is no perfect solution to this. We believe this is a better solution, a much better solution than Batson, which everybody agrees doesn't work. In fact, it was the St. Cali decision 3 years ago. Let me see if I can that really brought this head, and I think there's probably a number of you out there who are saying, yeah, I mean, I'm a trial lawyer, and you know, Justice Gonzalez is a good friend of mine. I told him, Steve, you can take one of our primary challenges. We tried it from my dead, cold fingers. And he and I go back on this. And it's so true. So the ACLU convened a group, and in fact, in this very room about 3 years ago, almost 3 years ago, believe it or not. And there's maybe about 20 or 30 of us who started looking at this thing. And over time, it dwindled down, as most things do in life, right? I mean, you find it kind of dwindling down to a small core group, where there really was a core group of about 6 of us for the last year working on this thing. And but during this whole thing, we looked at, in St. Cali, at least Justice Wiggins was going in there, he's saying, well, look, there's a number of ways, maybe this isn't the case for it. It hasn't been briefed, no one brought it up. And, but you know, this is a problem that needs to be fixed. So maybe we can do it legislatively. Yeah, right. Legislature, it ain't happening. Maybe we can wait for another case to come up, maybe, you've got a lot of opportunities so far, nothing's happening. Or maybe we can do it by court rule. So one of the first things our group did was, okay, well, what makes the most sense? Do we wait for another case, try to get involved with that? No, a court rule seems to be the way to go. And so that's what we've been working on. About 1 year ago, we had pretty much, after a lot, believe me, a lot of meetings, a lot of going back and forth on how to approach this, we had what we thought was a pretty good working model. And then we actually took it out to a number of stakeholders since that time. Oops, what is this? It is now before the Rules Committee. I am fairly confident that it's going to be sent out for comment. And so I'm so glad that all of you are here because, at least for those of you who are going to be supporting this rule, we need your help. For those of you who happen to be against the rule, just forget you ever came here today. And we'll have about 60 to 90 days to get all our ducks in a row. But we've had a lot of positive feedback, but there have been some pushback, which I'll talk about. But first, you know, Laurent, what is this thing doing?
You want me to just use the
laptop? I don't know what the... Okay. So, the one thing that you'll hear from the Batson, and the hardest thing, in fact, I'm just going to this next slide, but the worst thing about Batson is that basically, and I'm using kind of a broad term here, but if you make a Batson challenge, if you're saying, you know what, Mr. Your use of the peremptory was improper under Batson. What I'm saying is, basically, Fred's a racist, right? Because I'm saying, under the Batson framework, that the circumstances show that he's doing it for purposeful discrimination.
Is there some reason you're singling me out?
You know what defensive here?
Jewish area.
So it's purposeful discrimination. I'm not even saying, you know, he doesn't even know that he's doing it. I'm saying he's doing it on purpose. How hard is that for me making the challenge in the first place? Then, of course, and we'll go through this in the second, as LaRon said, you know, the second thing you have to do on Batson, okay, I'm the one using peremptory. I've got to come up with a race-neutral reason for why I made the challenge. You know, I think the Washington Post, because there was a big U.S. Supreme Court case, of course, my memory, so I can't remember the name, was decided last year, it came out in May, but there's a lot of coverage. New York Times writing about it, Washington Post, and it said, you know what, only the most incompetent attorney can ever fail to come up with a race-neutral reason. I mean, you know, it's funny, if you listen to this More Perfect, they have this great moment where 3 months after Batson comes out, and it's on YouTube as well, so it's an hour-long clip, but More Perfect does a much better job. There was a district attorney out of, I think it was Philadelphia, 3 months after Batson said, oh yeah, this new case of Batson, so what I want you to do is in your little box, as you're going through, just write down, you know, race-neutral reasons, like too close to the age, or lives in the wrong neighborhood. And so when you get a challenge, you just say, well, the prospective jurors too close to the age of the defendant. That's a race-neutral reason, right? I mean, color of your shoes. Purple shoes, I got a problem with people who wear purple shoes, you know, because they don't believe in law and order. That's a race neutral. That's a race neutral. See, I'm picking on someone else, right? Are you happy now? That's a race neutral reason. That's how low the bar is. But let's say that, you know, then what does a judge have to do in order to sustain a Batson challenge? What's that high bar again? Purposeful discrimination. You are doing it, you are doing it because my skin color is brown, that's why you want me off. I mean, how hard is that? I mean, my gosh, you'd be surprised if Batson challenges ever succeed. They succeed once in a while. Usually after, you know, on their fourth person of color, when someone's going, okay, I'm challenging juror number 15, I want to use my peremptory, on the fourth person of color, then maybe the judge will look at that. But that is how high the bar is. So we're trying to flip that around, okay, while still saving peremptory challenges. Okay? You are no longer going to have carte blanche, as you do under Batson, for the use of peremptories. But you can still use them, and probably just in a little more restricted way. Now, when I present to this, I always remind people, let me see, we'll get to that in a second. You still have your challenges for cause, which in my view, you know, as a trial lawyer, I always try to get off people for cause and save my peremptory. As a civil trial lawyer, when he gets 3 peremptories, you know. Criminal ones get a whole lot more. So they're very valuable. And I will always try to get people off for cause first. And it's, you know, and that's the thing, even voir dire, this is kind of getting off on a tangent, just isn't done very well these days. Because it isn't art, gently taking with something, because it's tough, but you can do it. And saying for this certain circumstance, you have some biases. And it can be done, it's not easy, it's art. You can usually get off the worst people, then you're off for some middle people that, for whatever reason, you can't get off. And I always tell judges, you know, you guys may have to be stepping up to the plate now, too, because it's too easy to say, well, you haven't established cause. No, it isn't. You know, Your Honor, in that example by Jeff Robinson, there's no way that officer is going to come in here fair and neutral. You know that. And it's copping out and making me use a peremptory on that officer. Under our rule, and I've been telling judges like this, you know, you may change the dynamics. You may have to be stepping up. So Kathy Moore, if you get on the bench, remember what I'm telling you right here, okay? You may have to be stepping up more than they do now. So, let me go through on the 3 steps. So, first step, may change. These slides roll out of order. Anybody can make an objection. Now, under Batson, even a judge now, but I don't know if judges really know that. Our rule is explicit. The judge can make if you will, an objection as well on their own. So you don't have to wait for a party to do that. And you don't say there's purposeful discrimination. The standard is very low. If an objective observer, someone outside this courtroom, could look at this and say, you know what, I think one reason, couldn't have to be the deciding factor, but one reason that attorney made that use of that peremptory challenge was because of race or ethnicity. That's all you have to do. So then the second step is that the attorney using the peremptory has to stand up and give the reasons. Okay? Not just, hey, I think that you got to give all the reasons why you use that peremptory. You better have something more than they live in a wrong neighborhood, because you're probably not going to cut it when there's one black person on the jury and you just got it off from them. And the third step where it makes a difference now is the court, the judge, has to look at that, has to evaluate all the reasons. So you're not just looking to see whether there's a race-neutral reason. The judge, she has to look at all the reasons now and say, well, could an objective observer, looking at all the reasons given, conclude that in fact race or ethnicity was a factor for use of that peremptory? You can see the bar is much lower. And then we go on to explain certain comments. Comment 2, what is an objective observer? And so this is different as well. So Justice Wiggins, in his opinion for the St. Cali decision, said, look, we have to address not just intentional, explicit bias, but in fact implicit bias, which is huge. Anybody who's been studying this, we're just becoming aware of the fact that we're not aware of so much. And so that's, an objective observer, one who's aware that purposeful discrimination and unconscious implicit institutional bias have resulted in excluding potential jurors. And historically, this is what happened. And judges say, well, how am I going to put my mindset into this? We know, I'm kind of looking for the perfect judge here, but this is a signpost for the court to say, this is what you're supposed to be doing. So, I just spoke at the fall judicial conference saying, this is, and they have been, and the judges have been looking at implicit bias, and they know that they have to do that. So I want to commend the judges, and they're going to have to keep on doing that, especially if we have the standard. But even if they don't, that's something that they're going to have to do. So so it's not the judge, it's not how a party would look at it, but how an objective observer would look at it. Fred?
You've got the word "and" up there.
Yeah. So
is the rule written with "and" in mind, or is the rule written with "or" in mind?
No, and. It's both. It's everything. Well, say, this is what lawyers are going to say, well, it should be an or there, and an or. It's all encompassing. Both, you have to be aware of intentional discrimination and unintentional discrimination. And if you are, would you say, well, look, is this a result of implicit bias, the reason that you did this? You may not even know. And that's an easier standard, much easier standard to reach, obviously.
So can I clarify that? So do you have to have, so I understand what you just said to me, there has to be purposeful discrimination and implicit discrimination.
No, just one or the other.
One or the other,
Right.
Okay. I'm just bad at grammar.
Yeah, it's, and we'll take a look at this, but. So there are a number of comments. Do you have the proposed rule? Did we pass that out?
No.
So we've got the main rule and we have a number of comments to the rule. So let me go through some of the comments. So there are a few things, a few classes. One is, what we've seen historically is that a lot of times an attorney won't ask any questions, maybe ask one or two. Everybody else gets questioned a lot. And lo and behold, who gets kicked off the panel? The person who answered, oh yeah, I work as a postal carrier, who happens to leave now. Right? And so that's a red flag. And we note that it's something the judge has to look at. Or if for some reason everybody else gets like 2 minutes to question, but one person for some reason gets grilled for 10 minutes, just trying to find stuff. The judge is supposed to look at that. Doesn't mean that they, it's dispositive, but that's something they have to look at the amount of questioning and the degree of questioning. So that's a comment because historically we've seen that as a problem. Comment number 4. Now there are certain questions, and again, you just see this coming up case after report a case. the prospective juror's age was too close to the defendant. They lived in a low-income neighborhood. They've been stopped by police, or they have a close member of family who's been stopped by the police, or they have someone who's close to them who's been in prison. Those kind of things, just by themselves, and they said, that's the reason I used my peremptory. That is no longer going to be, if you will, winner for you, because there's going to be a rebuttable presumption. Those don't work. If that's all you're given, that ain't going to work. Okay? Because that really doesn't tell you anything about this juror. Just again, you're lumping this juror that's been historically used to keep people of color off of the panel. So that's common, and that really is, and I'll tell you right now, that's the biggest pushback I've been getting when I've been talking to groups about that. Because people say, well, what happens if they do have a negative experience with the police, right? Well, you know, you go into that, you see what that was, and you bounce it out. I mean, you've got to question, that's the thing, you've got to conduct good voir dire, and see, you know, I mean, if I'm questioning Mark here, and he says, yeah, you know, I mean, I've been stopped by 3 times by police officers. One time they yanked me out of the car, threw me down to the thing, and I said, well, do you think because of that experience, because, you know, one of the main witnesses here is going to be Officer Mary Jones, is that going to affect the way you look at it? Don't you think that it's going to affect your case the way you're going to look at it a little bit? I would start taking him down that road and getting him off for cause without showing that, in fact, it will influence. I mean, how would you not be influenced by something like that, right? But just the fact that he got stopped 3 years ago for a traffic ticket and nothing ever happened to it, that can't be given a reason. Again, you're looking at the totality of the circumstances now, and there is no magic bullet where you can just say, oh, well, you could have gotten stopped by a police officer 3 years ago, and that's why I used my peremptory. That's not going to work anymore. Again, well, for Mark it would, but assume Mark has my skin color. Then it won't work, because it's race or ethnicity. Okay? Race or ethnicity. Unless, of course, we're in the Deep South. But we're not in the Deep South, but we're in the Deep South. And in fact, the panel was mostly black. Mark was one of the few white jurors on there, which we've seen, again, because the defense counsel will then take the easy way out and say, well, I don't want a white person on because my client's black. Can't do that. So it works both ways. In Washington State, I don't think we're going to be seeing that much. But ours is also race neutral. It goes both ways. It goes by that. Because you cannot use race. As part of our society, we do not use race as something that you can make judgments on. Because you can't lump us all in one category to that pound scale. 14th Amendment is one thing. But just from stepping back and thinking about it, that's not the way we want to have our society. Race. And I'll get to the gender thing in a second. Finally, as far as our comments, we have comment 5. And historically, we've seen that a lot of people will have an excuse for taking someone off and using peremptories because they'll tell the court, well, I used my peremptory on number 16 because they weren't paying attention. You could tell they were checked out during this whole process, Your Honor. We need people to attend, where they're falling asleep, or believe it or not, they're chewing gum. That's another one. So if you want to do that now, you can still do that. I mean, if someone's checking out, and anybody who's done peremptories, I'm surprised anybody can stay awake during that peremptory challenge, you know, showing that you're really involved. But if you want to do that, our comment says what you have to do first is that as soon as you see that, you take a sidebar, you do something, you say, Your Honor, opposing counsel, we have a sidebar, and say, you know what, prospective juror number 18 is checking out. She's falling asleep, dozing off, not paying attention, you know. And that way, I, as the opposing counsel, will keep an eye on that prospective juror. The judge will keep an eye on that prospective juror. See, in fact, whether it's true. So it's no longer just your word for it and saying, oh, you know, juror number 18 is checking out. The way that we have crafted the rule, and we are still going through the process, in the end, I got a lot of feedback on the gender, because when we first crafted this rule, it's just race or ethnicity. That's where we saw the biggest problem. However, since taking it on the road, since this latest iteration, found that in fact in some courts, it's gender as well. Gender used to be a big problem, you know, 20, 30 years ago. We haven't seen it, at least my experience. I usually have to have more women on what ends up being the jury and the big panel to begin with. So, and our group experience was it was no longer a problem. We learned that, in fact, in domestic violence court, which I don't practice in, what happens is prospective jurors are excluded because they're women, and you can see that consistently. So our committee is going to be meeting next week, and we're going to be looking to see whether, in fact, we should cover gender as well, and then how do we approach that. So I want to point that out to everybody who will see this. You may say, well, what about gender? I'll give you the reason before. Will it be changed? At least in my minority, get one vote. I'm heavily leaning yes for including gender, because it is a problem. I just didn't think it was. And we want to make sure we get through a rule that gets through and has some impact. Going through. And I think as LaRon said, Batson, because of the problem, it really does affect, and I can't stress this enough, it affects me, the person. If I'm a prospective juror, I get it, right? I'm the only brown person up there, and who gets knocked off? Not because I'm looking at what I said. I didn't say anything anybody else said, and I get it. It really does impact me, and that is, there's two ways of really engaging, if you will, in our society. One is voting, two is serving in a jury. And because you're knocking me off because of my skin, it really has a huge impact. It has a huge impact on the parties, because parties know what's going on. It's not fool anybody. And it affects the integrity of the whole system. It really does. The studies have shown that the more diverse group you have for any decision-making process, and they get it with jurors as well, but the more diverse you have, the better decision-making you will have, as opposed to a kind of a uniform thinking group. So it affects the judicial process as well. So we're excited about this proposal. We've been getting primarily affirmation with some pushbacks, and there will be pushbacks. And again, I think it will be sent out for publication. When it does, for those of you who are supporting us, please write it with the Supreme Court that this is a good idea. There may be tweaks in the language, but showing your support will really help us out. So I think we've got some time for questions and answers. At least questions, I don't know about answers, but we'll get to questions.